Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are going to complete our coverage of Massachusetts versus Kelsey Fitzsimmons. We are in closing arguments and verdict. And get settled in. It's been a ride, so grab something to drink, get settled in, and let's get started. All right, welcome in everybody. Thank you so much for joining us. So if you were with us yesterday, we were in the middle of the Commonwealth's closing arguments, and the prosecutor happened to display a firearm, and he proceeded to rack it, tap it. He was waving it around. If you guys were with us, you experienced that. We all experienced it together. Our stream was taken offline, and we were told, quote, let me find it. And this is a heads up for everybody else. None of the other content creators, news stations, court TV, law and crime, nobody else was taken down. For whatever reason, we were literally just taken offline. So it says, it looks like live court, Kelsey Fitzsimmons shooting trial, day 4 closings and verdict watch didn't follow our community guidelines. We removed it from YouTube. What we found, we think your content violated our firearms policy. Content that shows someone live streaming while holding, handling, or transporting a firearm isn't allowed on YouTube. Channels not in compliance with this policy may temporarily lose their ability to live stream. How this impacts you. We remove this content from YouTube. What to do next? Review your content and the policy. After your review, you can ask us to take another look if you think we got it wrong. So to which how we find violations. We use a combination of automated systems and human reviews to detect violations of our community guidelines. So, of course, we appealed it. We said, everybody else is showing it, NBC 10, Court TV, Law and Crime, probably 100 other content creators were out there. So we appealed it, to which they said, we reviewed and again confirmed it is not allowed under our firearms policy. Your video won't be put back on YouTube. We understand this may be frustrating, but we're committed to keeping YouTube a safe place for everyone. Our goal is to help you succeed on YouTube. We encourage you to take a look at our community guidelines and keep them in mind when posting content in the future. So we are going to show the closings again, but I'm going to have a thumbnail over Commonwealth's closing, so it will be audio only because we want to close the loop on this trial. We like to have this as a library for people in the future, so we want to be able, somebody wants to watch it from opening arguments all the way to verdict. and beyond, we want to provide that for you guys. So we will continue to play the closings. We're just going to have a thumbnail over that. So talk about a shared trauma, right? For everybody that was with us yesterday, this is a shared trauma. I feel like we all went through. We got blood on our cheeks now. We all went through this together, and the outpouring of support from you guys. We posted on Twitter. We posted on Facebook. We posted in Patreon, Blue Sky, on our community page. And you guys are great. I mean, you guys are the best. The comments and the support coming back, to how much you love and support us, and you miss us, and you're not going to watch the verdict anywhere else. To YouTube, why are you doing this to Trial TV Live? Why not all these other channels? So that really means a lot to us. We really, really appreciate your support, and it just was. It's so wonderful to know that you guys have our back. We have yours. We have created a great community here, and it's a shame that YouTube looked at this as if we were doing something wrong when everybody else was doing it as well. I guess if other channels had gone down, I would have been like, okay, I get it. But nobody else was taken down except us. So I don't understand that. That's another thing, is that they don't really explain more. I mean, they explained why they took it down, which is fine. Hey, I get that. I wish they'd given us the opportunity to clip that, but they just ripped it down, and then they didn't say when we were going to be able to come back. At first they said 24 hours, and then Aaron was talking to somebody, and they're like, oh, it could be 7 days, it could be 30 days. You could be banned for life. We were facing that. About 4 hours ago, we could be banned for life. So you can imagine what was going through our minds at that point. So all that being said, we are back. Thank you, Kimbers. Thank you, Alice. Thank you, Good Vibes. Thank you for the financial support. That means a lot to us. And guys, just thanks for coming back and watching with us. I watched it yesterday, so I know what happens. If you guys didn't see it, don't do spoilers. Stick more with I wonder how the judge came up with the decision he came up with. So for those that have not seen it, let's not do spoilers. Hopefully you guys haven't done any spoilers yet. So let's keep it like that. And without further ado, let's get to it. Let's get to it. So these are closings for the defense first, and then I will do Commonwealth closings, and I will put the thumbnail back up. So get settled in, and let's watch it together, guys. Again, thanks for coming back. Thanks for the support, and let's check it out.
Hear ye, hear ye, hear ye. All persons having anything to prove before the Honorable Jeff Carter, Justice of the Superior Court, now sitting in Lawrence, but then before the County of Essex, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts, and this most honorable court. Court is now open. Please be seated.
Good morning, Your Honor.
Good morning.
March 26, 2026, Court in 2, Lawrence Superior Court. Calling the criminal matter of Commonwealth versus Kelsey Fitzsimmons, 2025, 77 CR 311. Scheduled today for continued jury waive trial. Could counsel will please identify themselves for the record.
Good morning, Your Honor. James for the custody.
Good morning.
Good morning, Your Honor.
Good morning.
Good morning, Your Honor. Martha Copley for the defendant, Kelsey Fitzsimmons.
Good morning. Good morning, Ms. Fitzsimmons.
Good morning, Your Honor.
Good morning, Your Honor. Timothy Bradle. With me is Ms. Healy, Ms. Hassan, Mr. Leonard.
Good morning, everyone. Thanks. You can have a seat. All right. So you folks ready to proceed?
Yes, sir.
All right. I don't say this for the attorneys who know this, but because the government, the prosecution has the burden, they go last. The defense goes first in their closing. And Mr. Bradle, you may proceed.
Thank you very much, Your Honor. May it please the court. Counsel, ladies and gentlemen. Your Honor, June 30th, 2025 was the worst day in Kelsey Fitzsimmons' life. Her whole world imploded. Her fiancé betrayed her. Her baby was being taken away. She was going to lose her house, her job. It was an incredible confluence of tragedy that was visited upon her that day. That day was about her, and she decided in the midst of what you saw testified to here, she decided to end her life. Patrick Noonan, when he came back up those stairs, Your Honor, walked into a suicide in progress. That gun was nowhere near him. That gun was already pointed at Miss Fitzsimmons' temple by Miss Fitzsimmons. She was a couple steps into the room. Officer Noonan, a gung-ho cop, highly trained, a SWAT guy, he'd already been ginned up all afternoon by the insane, ludicrous statements of Justin Aylaian. He had that in his head. He walked in, and like all of us are susceptible to, he made a mistake. He shot too quick. He reacted too quickly. And instantly, he realized that he had to adjust the narrative. And that was easy, to just add 6 words to the equation, Your Honor. He said, words to the effect, she pointed the gun at me. 6 words. What did those words do at that time period? Those words made him the victim. Those words made him the hero. And those words, most important, made him untouchable. Those words were a defense for his future, his life, his reputation, and they were conveyed to a very willing audience. His colleagues, his brothers, his family, the investigators on the case. So that's really what happened here, Your Honor, and it is a tragedy, and it is something that should not result in any further harm to Ms. Fitzsimmons. This should be over. This should be an acquittal, Your Honor. I want to talk to you about a few of the elements that I know you're going to be concerned about. So, first thing I want to talk about, Judge, is the lack of motive and the lack of intent. Because when it gets down to brass tacks, you know, I know that you're going to look at the law, you're going to look at the credibility determinations, and you're going to make your judgment. And here, this case fails the Commonwealth ship founders on the rocks of lack of motive and lack of intent. Let's talk about motive. Everything in life is motive, and it's ironic that, you know, us lawyers always say, oh, well, you don't need to prove motive, but you really kind of do. It's meant not be an element of the crime, but motive is everything in this business, Your Honor. Let's look at the motive or lack of motive. Fitzsimmons and Noonan are colleagues. They have already bonded over shared tragedies, shared experiences. They were okay with each other. They were friends. Kelsey thought well of him, and she thought he thought well of her. She knows he has a family. She knows who his family is. She's not going to harm this guy. She knows, Your Honor, that he didn't do this to her. She knows that Justin Aylaian did this to her. And she's, probably most important, she's been in those shoes before, serving restraining orders. She knows she's just a messenger. She knows he's just a messenger. This was the worst moment of her life, and she wanted to end her life. And how did she want to do it? She wanted to do it alone. She didn't want to involve these officers because she knew this was a selfish act. She came in here, and ironically, The most credible evidence that came into this case, Your Honor, was from the one person that didn't have to testify. And she came in here and she chose to testify. And she waived her rights and she testified. And she showed, Your Honor, that she's a moral person. She's a caring person. You will sit down and you'll deliberate, and you'll be drawing the inevitable conclusion that Kelsey Fitzsimmons is a moral person. You have to contrast that with the callous treatment of this case from the other side. Hey, we're going to go serve an order on Kelsey Fitzsimmons. Her ex-fiancé got an order on her, on Kelsey. Let's go serve an order. The answer, sounds good. Let's go. Talks to his neighbor. Oh yeah, I'm the shooter. I'm the shooter. She's a whack job. So you have to take these credibility determinations into account. And I know you're a gentleman, but you have to get down to brass tacks on who's who here, Your Honor. What else shows you that she's a moral person? She doesn't want to involve these guys. She's trying to get rid of them. She says, oh, the guns are over here, so she can go where they really are. She keeps trying to give Houston and Noonan baby things to bring downstairs. She's trying to get rid of them. She's trying to get them away from her. She wants to do this on her own. She doesn't want to have some sort of a situation where she gets shot by one of her colleagues and friends. It's understandable because she's a moral person. She waits for her chance. She gets to her room. There's a distraction downstairs. She doesn't know what's going on because she's focused on the job she's trying to do here, the tragic, awful thing that she's trying to do to herself. That's how you know she's telling the truth, Your Honor. You saw in the room, and I'll show it to you in a minute, the chest that she got the gun from. It's a chest on the floor. It has one of those pretty substantial lids that you would have to flip up to get the gun, locate the gun, pick the gun out of the 4 guns, and stand up. If Noonan was standing right there in the door frame, that would have never happened. All those events, that little series of events, he would have been able to stop it. He would have stopped it. It tells you that he's down the steps. He was interested in the distraction downstairs. He saw Kelsey folding some baby clothes, getting baby things ready. His attention, it's human nature. His attention was drawn to go back down the stairs. He walked down the stairs 2 or 3 steps, 4 steps, whatever. And Kelsey told you, straight up, that was my chance. And she took it. And she went in the chest. Exhibit 51, Your Honor, I'll show you right now. She went in that chest, flipped up that lid, got the gun, stood up. She told you, again, she's a moral person. She tried to keep the gun concealed. She made the motion like this, Your Honor, where she put the gun like this, and she kind of walked over here because she didn't want the police to see her with a gun. She held the gun to her stomach area. She walked to a clear area, and she put the gun to her head. And that's what I mean when I say Officer Noonan came back up the stairs, and what did he walk into? He didn't walk into some Rambo woman trying to shoot him in the face. He walked into Kelsey, who you now know a little bit from her testimony. He walked into Kelsey's room, and Kelsey had a gun to her head. And he walked into a suicide in progress, Your Honor. And the man that had just been holding her baby, that she chose to hold her baby, that she chose to feed her baby, walked into her suicide in progress. The gun was nowhere near Noonan. There was no threat to Noonan. And the law says that you may not, an officer may not use deadly force on someone who is exhibiting a danger only to themselves. And that's offered to Your Honor twofold, in the sense that it shows that this was not a reasonable use of force, and it shows you that his knowledge of that statute, as he said on the stand, gives him a motive to lie. He knows that this is not a good shooting. He knows this is not a clean shooting. And that gives him a motive here, Your Honor. And like all of us, we all make mistakes. He overreacted and he shot. He had the look on his face, panic, flustered, he shot. He had made a mistake by leaving her there, walked down the steps, a few steps, and that gave her the chance. And when he did this, he knew immediately, Your Honor, that he had to adjust the narrative. Filtered through the legal lens, Your Honor, that tells us that Kelsey had no intent. She had no intent to harm Noonan. There's no assault here because she didn't have the intent to do so. As the fact finder, you can consider everything I said about motive, that she lacked any motive to harm this gentleman. In fact, it was the opposite. She thought well of him. She knew Justin did this to her. She had just trusted him with her baby, and she had tried several times to get these officers away from the situation. No intent to harm him, no motive driving her mindset to do so. Reasonable doubt, burden of proof, Your Honor. Where the evidence supports a reasonable and more plausible alternative, and that's shown here by Kelsey's testimony, it cannot be said that the Commonwealth has proven their case beyond a reasonable doubt. There is reasonable doubt. When there are two plausible versions of what happened, that itself is reasonable doubt. The versions themselves, Your Honor, show reasonable doubt. Kelsey's version rings true. Noonan's version is all over the place. Noonan's version is contradicted by the strong consensus of everybody else in the house. Noonan portrays a couple different stories, but if you want to pick one where it's this drawn-out potential gun battle, where she's backpedaling, sidestepping, tapping, racking, there's commands going on, that takes time. It takes time for me even to say it. Never mind do it. And that's belied by everything everybody else in the house says. Everyone else says, Kelsey no, 2 shots in quick succession, bam, bam. That does not fit with what Noonan said happened. So on that alone, Your Honor, as a fact finder, I suggest that your duty is accomplished quickly, because there are two extremely divergent versions of this event. And Noonan's version has changed itself. Noonan's version is inconsistent with who you now know Kelsey is as a person. It's self-serving. And like I said, it makes him untouchable. And when you judge it against everyone in the house, he's the only one with the Rambo story. Everyone else has what Kelsey says. He walks into a suicide in progress, he sees it, he reacts, Kelsey no, bam, bam. Brain freeze, mistake. Has to cover it up immediately. What else do we have? When you're a fact finder, Your Honor, you want to look for corroboration. What's the corroboration on either side of this thing? Or lack of corroboration, which is what really it is here. The big one, the big elephant in the room, is that this department has no body cameras. We wouldn't even be here if they had body cameras. There's no evidence other than people's words. He said versus she said. That's oftentimes, almost all the time, not a good place to start for the Commonwealth. How many of these guys didn't do reports? What's up with that? Why didn't Trooper Strong put the body camera video on the witness he's interviewing? There's no science. The testimony of everyone else in the house shatters his narrative. Kelsey Fitzsimmons has been blessed. She should be dead 2 times over, by her own hand and by the hand of Officer Noonan, who shot too quick. She's blessed. She's here today, and she has a new lease on life. And maybe that's why the investigation is what it is. And maybe that's why Noonan's story is so sloppy, because nobody expected her to be here today to tell her truth. But she is, Your Honor. And as the fact finder, I want to respectfully ask you to consider the evidence, consider the lack of motive, the lack of intent, the inconsistencies. The credibility contest is firmly in her camp. She came in here and she told you what happened. Unvarnished truth. And I ask you to find her not guilty. Thank you, Your Honor. Thank you.
All right, so here's where I'm going to put up a thumbnail so we don't get smacked again. Hey, Wall, yes, we are back. All right, what did you guys think of Mr. Bradle's closing? What did you guys think? I know it's only up for 2 minutes. So hit it out of Fenway Park, which is a home run. That's the top one. Hit a double, which is pretty good when you hit a double. Hit a single, not bad. So it would be like 100% would be hit it out of Fenway Park. Hit a double would be like 60%. Hit a single would be like maybe 30%. Struck out on 3 pitches would be 0%. So right now you guys are saying 30% hit it out of the top, hit it out of Fenway Park. 28% of you said hit a double. 32% of you hit a single. 9% of you struck out on 3 pitches. I went with hit a single. I was watching, I think, Defense Diaries yesterday while the verdict was coming in, and I think Bob was saying, every lawyer has an off day, and that's true. I get it. Not everybody can be, top of their game throughout an entire trial. Granted, this was only a 3-day trial, but I was thinking, what a bad time or what a bad day to have a bad day. I could see if it was like a 7-day trial, a 3-week trial. But it's only a 3-day trial. This is day 4, and these are your closings. And I didn't really think he stuck to truth. Or I'm sorry, no. I didn't mean to say that. I meant to say like evidence, like facts, right? He was more or less saying, go with Kelsey because she. I don't know. It's a tragedy. Shouldn't result in any further harm. It should be over in an acquittal. It's her worst moment of her life. She wanted to end her life. I don't know. The most credible evidence came from Kelsey. She's a moral and caring person. Does that really have to do with evidence? I mean, I'm sure she's, yeah, sure. I'm sure Noonan is a moral and caring person too in his own right. I don't know. I just felt like there was a lot. He could have done more. I did like when he said, flip the lid, reach in, choose from one of the 4 firearms. Shows Noonan wasn't. I like that. Held it to her stomach and walked to the clear. I like that part. Noonan comes back in. He doesn't see a Rambo woman pointing it at his face. He overreacted, panicked. So there was some, and I also liked lack of motive and intent. I did like that. There was really no motive for her to take out Noonan. There really was none. And then she'd have to and people have been saying this, I think Runkle said it a couple of times, she'd have to John Wick her way, Rambo basically her way through the house. And then what? She's going to take out 3 of her colleagues. She's 3 of her friends. She's friendly with these guys, And then what? To what end? Then take out Justin just to then go on the run? I mean, she'll be arrested within hours. She's got a baby, for crying out loud. Her mom's in the house too. So I don't buy the Commonwealth's theme and they're saying, she pointed this at Noonan, and to what end? I don't know. I'm not buying that. So that's why I'm like, again, you guys have been talking about this a lot. If both sides are correct, right, then you have to go not guilty, because the Commonwealth did not meet their burden. The Commonwealth did not meet their burden, in my opinion. I don't think they showed that her intent was to take out Officer Noonan. To what end? To what end? I think there's a little bit of truth in both of these. I think she was trying to take out herself, self-delete, and I think Noonan saw it and he freaked out. Why he didn't just say, wow, you pulled a gun and I reacted to it. That's what my training is. I don't know why he just didn't go with that story. I think he would have been acquitted. Kelsey probably would have been like, hey, no harm, no foul, even though he put me in the hospital for 53 days. But at least she wouldn't be on trial and going through this. It would have just been like, yeah, you pulled this, and I didn't know what you were going to do. And if anything, I saved your life. I know some of you have been saying that. He did, in essence, save her life in a weird, messed up kind of way. He saved her life. I mean, just think about that for a second. If she had been able to do her whole racking and tapping and all that stuff, and she was actually able to, or if there had been a projectile in that chamber, she wouldn't be here right now. So in a weird kind of way, Noonan did save her life. Right? It's crazy. All right, I'm going to end this poll. Let's see where we stand. And then I'm going to put the thumbnail up. P. Cooper, yeah, Runkle had her dressed as John Wick. Oh, did he? I didn't see that. I just heard him talking about it. We watched him last night too, just to see what he would do. And he didn't play it either. He didn't play this either. And he was saying, hey, there's streams out there that are getting channels that are getting smacked, and we know who that is. So, yeah, it's it's really weird. It would have been like if other people had gotten smacked, I would have been like, okay, I get it. This guy was waving it around and racking it and all this stuff. Why us? I don't know. All right, time for the thumbnail, and I think we should be okay. I think we should be okay with audio only. I think we should be okay. So let's go. Lazy Boys, did somebody report us? I don't know who. I mean, I'm not going to go down that rabbit hole, that conspiracy. Maybe. I don't know. I don't know. I don't know anybody that would want to do that. I mean, what is what it is. We move on. We move forward. All right. So audio only.
Yeah.
Right now he's at the table, and they're pulling out said firearm. Selena K, because I am mad that you were the only one. Thank you. I really appreciate it. Thank you, Selena. Yep, he's got it, puts it on the desk. I mean, it's just, I don't understand why he's just being all willy-nilly with this. What did you guys think about the closing? And now the camera zoomed in on it. All
Yes.
Every piece of credible evidence in this case proves one thing, that she's guilty. All the testimony, the scientific evidence, the physical evidence, the demonstrative evidence, everything points to one conclusion: she is guilty. Even her own testimony proves she's guilty, because it's impossible to have happened the way she said it. It is scientifically, mechanically impossible for it to happen the way she said it. Her story is that she grabbed a gun, put it to her head, pulled the trigger, and it clicked. The chamber was empty. That's what her story is. And that's what Officer Noonan's story is, too. She pulled the trigger, click, nothing came out. There wasn't a round in the chamber. She even said, she told everybody how stupid I am. I tried to kill myself with an empty gun. But what do we know about the gun? What do we know about her gun? Because after she went to the floor, Lieutenant David picked it up, put it on the bed. Officer Noonan picked it up and put it on the table. And then Officer Kaur came in the room. And what happened then? Officer Noonan said, secure that gun, make it safe. And so what did he do? He took the gun, he found that black box, the safe. He made sure that was empty. He turned it over. He pulled out the magazine that you can see right here. He opened the chamber, and there was a round in the chamber. He dumped it out into this safe and put the firearm in there. And then they stood watch on that until State Trooper Bonasara took it back in the lab. That magazine that you have in evidence contained 16 rounds. It was a 17-round capacity gun. It contained 16 rounds, plus the one that was in the chamber. 17 rounds. As we know, there are only two ways to get a bullet into the chamber. One is if there's already a bullet in the chamber. Someone pulls the trigger. A bullet comes out, the casing comes out, the chamber's open, the spring allows another bullet to come up. That's one way, and we know that didn't happen here. The gun didn't fire because the chamber was empty. The only way a bullet gets in this chamber, other than that way, is if someone racks the gun. She said she didn't rack the gun, but there was a bullet in the chamber. She did rack the gun. What did Officer Noonan say? She pulled the trigger. Nothing happened. She stepped back, tap racked, tried again, didn't do it. Tap racked again, pulled it, and that's when he fired. She put a round in that chamber. That's the only way it got there. Her story can't be true. She got up on that stand and she lied to you. It's scientifically and physically impossible for her story to have happened the way she said it. That's what the evidence shows. But she didn't just lie to you then. She lied again. She lied at the scene about where the guns were. And she admitted that, and I understand that, right? And she said she lied to the police because she decided to kill herself. But when did she say she said that? They had been to the house. They had talked to her, according to her. She now started contemplating all of the ramifications of what's going to happen to her. Because she's losing her life, her job, her son is being taken away, all of these things. And so she's going that over her head. And then minutes later, as she's walking through the house, She says, my gun's in the basement, because that's the time she made the decision to kill herself. Later on. And we know that's a lie. We know that's a lie because what was one of the first things they asked her when they went to that house? They asked her to put the baby down because they were concerned for the baby, told her the restraining order, what the parameters were, and asked where your guns are. When she was still sitting on the sofa. They weren't waiting to ask that question until she was already walking around the house. No way. And what did she say there? They're in the basement. And we know she said it there before she moved around the house, which is untrue. Because her friend, Officer Houston, who was invited to her wedding, says it also. He says, Sergeant Daly asked. And then remember what he said? He said, I was in the living room, she was sitting down, and then I saw a gun case on the other sofa. And so I opened it up to see. And she said again, I already told you the guns are in the basement. Now, why at that point did she say that? We don't know. She didn't tell us, because she lied to us about why she said it later, because we know she didn't say it later. So she lied again. You can't trust her. She also lied about knowing that her mom was in the house. She was upstairs. The officer, Noonan, I think it was, Noonan heard an older woman's voice down there and said, who is that? She says, I have no idea. She doesn't know her own mother's voice, her best friend that she just talked to come to the house. And she said she didn't know whose voice it was. Another lie. She said on the stand yesterday that she didn't know Justin was in the house. And we know that's a lie too, because what happened when the three of them were upstairs? It's Noonan, it's Houston, and it's the defendant. She hears him downstairs. Houston hears him downstairs, and she says, keep him away from me. I don't want him in my house, or something to that effect. And that's when Houston went down to make sure he wasn't coming up and went to the basement. She knew he was in the house. She absolutely did, and she lied to you when she said she didn't yesterday. And you know what else she lied about? Something so simple, but it shows who she is. The restraining order. She said the restraining order was taking my dog away. It says it. It doesn't say that. Nothing about the dog in there. I could go on about the lies, but I want to talk about the credible evidence. The credible evidence in this case. When Lieutenant Daly got a call, actually got a visit from Justin Aylaian when he was in the lobby of the PD. And Justin told him he got a 209A against Kelsey Fitzsimmons. And Detective Daly knew that she had been sectioned before, that she had guns, that they were taking the child away from her for a period of time. And so what did he do? He called Officer Houston. He asked Houston to call Daly to meet up. And why did he say he did that? He said because those two are cool, calm, and collected. They don't panic. They keep things calm. That's what he said. And that's why when he called Houston, he said, can you call Daly? We got to do this. And so he wants you to believe, defense counsel, that Pat Noonan was cavalier about, oh, okay, sounds good, we have to serve a restraining order. But that's not what happened. He was mischaracterizing it, I hope you remember, in the grand jury minutes, because Houston had called Pat and said, hey, we got to serve an order, can you meet me by the school? And Pat said, sounds good. It wasn't until he got over there, it wasn't until Lieutenant Daly was there that they learned really what they were going to do. And they went over there. And defense counsel asked Daly, you guys were cavalier about it, you knew her, weren't worried about the guns, all this stuff. And Lieutenant Daly said no. No. His quote was, we had an increased level of diligence. Everyone was more on point because they did know what they were walking into. They did know. They did know that she had been sectioned before. They did know there was going to be a baby in the house. They did know that she had guns. They did know at that point that she had parked her car far away. This is all going to what they were thinking at that point. They did know all those things. And they did know Justin's concerns. He said, according to Lieutenant Daly, I'm worried she's going to kill the baby, kill herself, and kill someone else. So that's what they were thinking when they went into this house. That's the credible evidence when they went in there. And what did they do when they went in there? They sat her down, and they allowed her, or maybe they asked her, I can't remember, to go around and get some stuff for the baby because she knew Justin was coming to get the baby. And they were in her pocket the whole time. They followed her around the house, at least two of them, while she did that. And you know that because even Officer Houston said, I was in her pocket. And we went into the kitchen, and I noticed there were butcher blocks with knives on them. With knives in them. And they were concerned. There was no chance they were leaving her alone. No chance they were leaving her alone. Officer Newman. All of the testimony that you've heard about Officer Newman, even from the defendant, he's a gentleman, he's experienced, he is by the book, and his training and experience starting in the military, through boot camp, through security forces school, security forces squadron, with all the training he had, and Humvees and helicopters, and the SWAT team, 2 times a month training, clearing rooms, clearing buildings, hostage situations, missing persons, shoot, no shoot scenarios, twice a month, and a 40-hour block every year. For over a decade he did that. And he moved to Lawrence, as far as the department goes, because it was busier, and he had more experience. He was cool, calm, and collected. There's no doubt about that. And to say when they're upstairs and he walks away and leaves her alone because he heard a commotion that Officer Houston was going to attend to is a joke. It really is. Now, how do you know they were going by the book at that point? And how do you know they were vigilant? Because they followed around everywhere. Because both Houston and Officer Noonan said she kept handing us things, and we kept putting them down. We wanted our hands free. Because they were ready for whatever happened. Hoping nothing did, but ready for whatever happened. So at some point, Houston and Noonan are upstairs, and the defendant goes into her room. And she hears Justin. And Houston goes down to keep the peace to make sure he's there. And Officer Noonan is watching her. He's watching her. And she's on one knee. And she lunges, and she disappears. And she emerges with this, pointing at him like she is trained to do. Click at his face. And what does he see next? He draws his weapon, and he says his testimony, it kind of slowed down. The whole thing took maybe 4 seconds, maybe even 3.5 seconds. His training has kicked in. His experience has kicked in. It was a surprise to him, certainly, because she got the drop on him. And why did she do this? Who knows? Maybe he's right. Maybe, she was going through him to get to Justin. Maybe she was just so upset she was going to shoot anybody in front of her. Maybe she wanted him to shoot her. We don't know because she lied about it. We don't know. But the fact is, she started to shake, she started to tremble, and she lunged for the gun that he couldn't see. And what happened after she clicked? She stepped back, and now he knows, based on his training experience and the click, there is not a round in the chamber. He knows that, and so he doesn't shoot. According to the defendant's testimony, he had every right to shoot at that point. And you know what? He actually did. He had a right to shoot her at that point. If you point a gun at a cop and pull the trigger, they get to shoot. But he didn't. Because he was controlled and disciplined. That's the way his career went. And so she steps back, tap, crack, and tries to do it. He doesn't shoot her then. And what's he doing at this point? Kelsey, no. Kelsey, no. Because he knows the threat isn't there, really, because there still wasn't one in the chamber. Kelsey, no. Kelsey, no. He is being disciplined like we wish every police officer, every law enforcement agent in this country was. He should be applauded for his actions on that day. Tap rack again. Now he knows one's in the chamber. Threat's on. She starts to raise it, and he shoots. He shoots twice to stop the threat. He stopped shooting when the threat was neutralized. Defense counsel, during his cross-examination, well, you would have unloaded her gun. He goes, no, that's not what you do. You shoot until the threat is neutralized. She was now down on the ground. But his training and experience are still taking over at this point, because what does he do? He still has his gun on her, because the gun's still there. He can't see it. Lieutenant Daly comes in, Lieutenant Houston comes up, and what does Officer Houston say that he sees when he comes upstairs? That Officer Noonan is standing there with the gun low and ready. His training is still taking place. He's still doing what he was trained to do. The gun is put on the bed. He's calm and collected. He takes the gun and moves it away so people are safe. He's deliberate in those actions. When it's away from her, he starts to tend to her. Officer Core comes in, and he asks Officer Core to make the gun safe. He's cool, calm, and collected. That's what Lieutenant Daly expected, and that's what he was. He didn't make a mistake. That's what the credible evidence shows. And what did he say to Officer Houston after? And this just goes to state of mind, I know. That she pointed the gun at me, and it clicked. And she tried to rack another one. Immediately after, this wasn't him saving his hide or protecting himself. Seconds after this happened, that's what he said. Every piece of credible evidence points to the unmistakable fact that she is guilty. Every piece of physical evidence, scientific evidence, mechanical evidence, every piece of testimony from Daly to Houston to Core, even Lauren Page, the mother, even the defendant corroborates what Officer Newman says. Every piece. Your Honor, I would suggest to you there is only one fair and just verdict in this case, and that is guilty. Thank you.
All right. So now I think we can go ahead and we can show. All right. So I had to do. Hey Barry, are you with us? Barry, come in. All right. So how do you think the Commonwealth did? Let me see how you did there. 53 votes. I'm sorry, 93 votes. All right, so for the defense, we did 31% hit it out of Fenway Park, 30% said hit a double, 30% said hit a single, 9% said struck out on 3 pitches. Now with the Commonwealth, 52% of you said something smells rotten, 28% said flat as a pancake and not good, 12% said lemon pound cake yummy, 8% said a bit flat but okay. I wasn't a fan of him waving that around. He did it, 4 or 5 times. He racks it. He clicks it even. Seems a little bit dramatic to me. I'm not a gun expert, so I did like his part about the only way to actually chamber that is to do what he did. And then also if Kelsey lied about this, what else was she lying about? She admits she was lying. It's nothing like that. Oh, here's Super Ball coming in. There you go, guys. Super Ball sighting. All right, you going to just hang out here? All right. You going to come and hang out with me? Good girl. All right. Super Ball is happy that we're back too. All right, good girl. Okay. Yep. Say hello to everybody. So it was dramatic for sure. Way too, yeah. And just for a judge, it's not like there was a jury. I could understand maybe if there was a jury, he could kind of get away with it. But just for a judge, so I thought he scored points when he said the only way to get that projectile in there was to rack it. But I also heard some other people saying, I think Runkle was saying an officer, Noonan could have very easily picked that up and racked it. It didn't just have to happen that way. So then also he's saying, well, she lied when she got up on the stand. She lied to you. I'm not so sure. I mean, she admits that she was lying to the officers to get them to go downstairs so she could, finish this thing. And then he said there was no dog in the RO, in the restraining order. So, Rock and Roll, you were saying you saw that. You saw the restraining order? I have not been able to see the restraining order. So I would love to get my hands on that so we could read that. We have the affidavit, but there's nothing in the affidavit that says we want the dog too, Maverick. So, all right, so let's continue on. And now we're past that. We've made it past YouTube. We got slapped before this, so we've made it past. So I think we're out of the woods. All right, let's continue on.
For sidebar.
I'd like to speak to counsel anyway at sidebar for scheduling purposes. All right, so while you folks are returning, counsel are returning to counsel table, I'm just going to, we went to sidebar for 2 reasons. One was Mr. Bradle has a series of objections that he'd like to lodge about the Commonwealth's closing, which I'm going to give you an opportunity to do in open court with the Commonwealth in open court responding. And also, I went over the schedule. So, as I told counsel, my intention is to take as long of a period of time as I need to reach a verdict, provide the court staff and counsel with 30 minutes notice, and come out and announce my verdict, some of my reasoning here in public, and whatever time that works. In other words, if it's during our traditional lunch break, so be it. You folks will have a half-hour notice. which means that you'll be able to go and have coffee or lunch or whatever as long as you can get back here. All right, so that's how we've worked that out. We also discussed at sidebar the fact that in a jury trial, we never provide the jurors with ammunition and a firearm, even with the trigger block at the same time. So my intention is that Mr. Ruane, our assistant clerk, will keep possession of the ammunition, and the firearm will come back in chambers with me along with the other exhibits. When and if I need the ammunition, they'll be switched out. All right. Okay. Globally, have I said in open court what we discussed?
Yes.
Okay. All right. So, Mr. Bradell, I'll hear you on the objections.
Thank you, Your Honor.
So, Judge, traditionally we do this at sidebar, but as you mentioned, we don't have a fact finder here that we need to talk off to the side to. So, in open court, I'm happy to do this. Sure. Yep. I'll go back over everything I said at sidebar, Your Honor. Judge, the first objections I have to counsel's closing argument center on ballistics issues. The first part is that counsel picked up the gun and used it 3 times. Prior to that, counsel provided what I would consider to be expert testimony on the operation of the gun. I think it exceeded the scope of what Detective Bonasaro talked about. He said that it had to be a scientific certainty that this gun was racked by Kelsey Fitzsimmons. Mischaracterizes the defense position that we're not saying necessarily that it did or didn't happen. We said that Kelsey Fitzsimmons didn't rack the firearm. And we have a completely different version of events. So no one's saying that it didn't happen. We're saying that Kelsey didn't do it. And to characterize it like, that it had to be racked by Kelsey Fitzsimmons is not fair argument, and it mischaracterizes the state of the evidence. The second objection relative to ballistics, Your Honor, is that counsel was acting out. I believe it was the second time he picked up the firearm. Counsel was acting out on Noonan's story that Ms. Fitzsimmons had accessed the firearm from the chest and picked it up to point it at Noonan's face. And on Noonan's testimony, she just pulled the trigger and it clicked. Counsel's acting it out. Prior to pulling the trigger, counsel racked the firearm and then pulled the trigger. And that's not what happened on even Noonan's testimony.
I'm happy to allow you to make a record, but the fact that there's 2 different versions of what folks testified about is fair game. What the issue right now is whether the Commonwealth argued items that were not in evidence or attempted to draw inferences from items that were not in evidence. So the disagreement about the racking is just not before me.
Well, that's why I bring it up, though, Judge, because this racking issue has been brought up to the forefront, and he did something that is not part of the evidence. No one says that she racked the gun before the first shot, and that's what he did when he acted it out. So that's why it's a mischaracterization. I'll just rely on Your Honor's discretion.
But that's not what Mr. Gubitosi did, though.
I did see him rack the firearm before he fired the second shot. He did it the second time, Your Honor.
Okay, I'm having trouble understanding. Again,
it's just that when you act out the testimony, you have to do it accurately, and he didn't.
I'm going to say this in open court, and it won't be the last time I say it. Whether or not Officer Noonan exercised reasonable use of deadly force is not before me. That is not my decision.
I agree with you, and I say it on credibility.
And hold on. And whether the North Andover Police Department followed procedure in executing, serving this restraining order is not before me. Child custody is not before me. All right? Visitation is not before me. What's before me is, has the Commonwealth proved beyond a reasonable doubt that the defendant pointed that firearm for any perceptible amount of time at Officer Noonan. Okay, so all of this is just not helpful.
And I offer it on credibility, though, Your Honor.
Okay.
Also, the Commonwealth said that on the scene, Ms. Fitzsimmons didn't say part of her story there, so therefore she's making it up. And whenever the Commonwealth tries to argue that somebody, a defendant, didn't say something, that's very dangerous ground for the Commonwealth, Your Honor, that the defendant is under no burden whatsoever to say anything, Your Honor. And here to suggest that she's lying because she didn't say part of her story when she's shot in the chest at the scene is unfair argument, but it also violates her right to remain silent. And it's an intrusion on that, so I would object to that. I ask you not to consider that, Your Honor.
Except that, Mr. Bradle, she waived her right to remain silent, right? She testified, so...
At the scene, though, Judge.
Isn't it fair game for the Commonwealth to discuss the testimony that your client offered?
The testimony, yes, but he's saying that at the scene she didn't say XYZ when she didn't have to say XYZ at the scene. And that's, the Commonwealth can only argue that when a defendant makes a comprehensive statement and leaves something out. Very present to my client that she wanted to kill someone else, which didn't happen. That was not the statement. So that's a very important, very dangerous, very unfair, very prejudicial misrepresentation of what was attributed to Justin Aylaian in the lobby. She never said anything about killing someone else. He didn't even he didn't say that she said that. So I ask you to strike that and not consider it. And the last thing, Judge, about lying about the dog on the restraining order, Your Honor, that trying to take her dog. And it is in the complaint to the restraining order by Justin Aylaian.
Objection. I know he's trying to do a second closing, but the evidence is what the evidence is.
Yeah, but Judge, you can't say, when you have the discovery on the point, you can't say that something is a lie when you have the papers that show it's not a lie. And the box was checked in the complaint to get her dog. So that's a mischaracterization of the evidence that needs to be corrected, Your Honor. And that's my last point. Thank you.
So, Commonwealth, from my perspective, with all due respect to Mr. Bradle, who's done a terrific job advocating for his client, I view that as nothing more than a rebuttal to the Commonwealth's closing. So I'll give you a few minutes to rebut these things. Let me say this, though. I don't believe that there was any evidence before me that Miss Fitzsimmons was sectioned previously. I think that the way I view the evidence is that this is what the police believed. It was part of their state of mind in serving it. But I'm at a loss, frankly, that, in other words, what I'm saying, Mr. Bradle, is out of all the items that you argued about the Commonwealth purportedly arguing something not in evidence.
Yes, sir.
This sectioning, alleged sectioning that happened prior to this.
Yes.
There's no evidence of that before me. There's mention of it, and it goes to the officer's state of mind. So, and that's all that in fairness, that's all that you argued, Mr. Gubitosi. But I guess what I was getting at is if there was anything at all that came close, that would have been it. But Mr. Gubitosi, I'll give you a few minutes for your rebuttal to the rebuttal.
I don't think I trust you to have sifted through what's relevant, what's not relevant. The evidence is what the evidence is. Closings are not evidence. I would suggest to you that, I guess I do need to be heard, that I argued the evidence that came from the witness stand and from the exhibits to Rubanasaro absolutely describe the ways that a firearm works and how a round gets into the chamber, and I limited my explanation of that to what he described and the like. I don't need to make a second closing. Thank you.
You just did that.
I did. I'm a lawyer.
Okay. Now, respect that, both sides. All right, so at this point, why don't we, I said that I was going to step off for the gathering of the evidence. Let me not do that. I'd like the council to just make sure that all the evidence, the exhibits are in order. You'll note your contentment on both sides. If you folks can take a look at the verdict form as well, I don't know if you already have. It's not complicated, but do you want, Mr. Braille, have you seen the verdict form?
No.
All right, so one of you, officer, do you mind? Officer?
Commonwealth is content with that.
Same.
All right, content with the verdict form, but we're still working on the exhibits,
Yeah,
right?
we'll take a few minutes.
Yeah, that's fine.
Yikes, what is going on? All right, while they do this, it looks like they're done. All right, Richard sent us something. Let me read this. All right, Richard says, I'll try to explain this simply. The main way to chamber a round with a fully inserted and seated magazine is to rack the slide fully. If the magazine is not fully seated, a fully racked slide will not cause the round to chamber. However, even with a fully seated magazine, a partial rack, meaning not enough force by the user, which would cause the round to be partially chambered, hence a click. Let's just say in this case either occurred. If a round was partially chambered, another rack would chamber it. But another possibility is that if the round was partially chambered, the pew falling to the floor with enough force would be enough to chamber the round fully. Hence, officers discovering a round in the chamber after the incident was over. We know a round was not fully chambered when she pulled the trigger because an audible click was heard. The other possibility is that Noonan had an oh poop moment and he chambered a round after retrieving it from under Kelsey to cover his butt. Yeah, then there's that. And it could have just been reflex, right? It could have just been like, could have been just been his reflex, to chamber it. I don't know. I just don't know why he didn't just be like, yeah, you pulled this, I reacted. I just don't understand that. Let's see, Conlan says, had the cops secured the firearms as they should have first and foremost, this never would have happened. Oh, P. Cooper, yeah. I don't have the restraining order. I just have the affidavit. And I don't see anywhere on here where there's a check mark for an animal. So I don't have, you're saying it's on the affidavit? I am not seeing it on the affidavit that he signed. It's just, I don't have it. You're saying it's on the, are you saying it's on here? Show me where it is. I'm not seeing it. Oh, goodness. Really? Hold on a sec. Let's see if we can do that again. Of course, it's not showing up. All right. first page at the bottom. If this box is checked, more space is needed. I, the plaintiff, complete affidavit, perjury statement, complaint. I'm not seeing it, you guys. All right, let me go back to it. Let me take a screenshot because my PDF is not working. So we'll do a screenshot instead. All right, you show me where it is. Show me where it is. I am not seeing it. You say it's on the first page at the bottom? First page at the bottom. I fear that she will delete the baby at any moment. She punched her stomach repeatedly. If this box is checked, which is not, I am the plaintiff and I complete this affidavit and I declare under penalty of perjury, statements are true. Complaint. Where does it say anything about a dog, you guys? Why am I not seeing anything about a dog? You saw it in a tick box. This is the first page and that's the bottom. It says animal. Yeah, it's a different document. That's what I'm saying. This is his affidavit, Joanne. This is not his RO. I have not been able to get the restraining order that she was served. She did not see this affidavit. She said she only saw the restraining order. So I have not been able to secure the restraining order. So this is Justin's handwritten affidavit. This is not his restraining order. Yeah. Yeah, that's what I'm figuring. It's on the court form, not his handwritten. Yeah, so it's the actual restraining order, which I don't have. I wasn't able to get my hands on that. That's not the document you saw. Yeah. Yeah, bummer. All right. No, I would love to see the actual restraining order. So, okay. All right. No worries. Is what it is. It's fine. All right. I'm going to fast forward to his verdict. Oh, it's okay, Joanne. No worries. No worries. I kept thinking it was on the restraining order. So. Oh, they got weather in here. All right, here we go. Here's the verdict. So initially he was going to have it 1:30, and then it got kicked to 2 o'clock. So here, I'll bounce myself over here. All right, so here is the verdict. And what did you guys think about the verdict? Here, let's get a poll going. We'll do a poll. What did you think about the verdict? All right. So we'll go with those two. A new poll for you guys. All right. So here's the actual verdict.
Verdict, let's listen in.
Speak to our audience members. I understand that this case has generated a lot of passion and emotion, but you must remember that this is a courtroom and not a sports arena. When I announce my verdict, you must not act out emotionally or visibly or audibly react. So you should leave the courtroom if you believe that you will be unable to maintain your composure. I'd like to start with a few introductory words. Let me say this. This is not in my script. This has been one of the more exhausting, hardest things I've had to do as a judge, as an attorney. And in any event. So, as the lawyers know, unlike when a judge presides over a jury-waived trial in a civil case, there is no requirement that a judge explain their reasons for reaching a verdict after a criminal bench trial. I do so in this case because I think that Ms. Fitzsimmons, Officer Noonan, and all the people involved in the tragic events of June 30, 2025 deserve an explanation. Next, I'd like to take the opportunity to publicly thank and commend the attorneys in this case. They all did an exceptional job presenting the evidence and conducting themselves in an extremely professional and civil manner. And they did so under the public spotlight in an emotionally charged case. I commend you. To the extent that any of the prosecutors and attorneys may be vilified or subjected to public scorn for simply doing their jobs, in this case, I say that any such scorn is unfair, unwarranted, and simply wrong. These prosecutors and attorneys fought hard, but performed their solemn jobs fairly with the utmost civility, and professionalism. They served as a shining example of our adversarial system in operation. Now, I'd like to publicly acknowledge the crucial and often thankless role that police officers perform, a role that Ms. Fitzsimmons herself, like Officer Noonan, willingly and selflessly performed for the citizens of North Andover. For this, you should be thanked, not disparaged. For those that think that serving as a police officer is easy, or that officers don't care or take pride in their work, I say with more than 3 decades of experience in the criminal justice system that you are naive, misinformed, and sadly mistaken. The work of police officers is especially fraught with peril today because of our exceedingly cynical, polarized atmosphere where our citizenry often believes that there is a conspiracy under or around every corner. I saw no evidence of a conspiracy in this case. What I saw was dedicated public servants like Officer Noonan and his fellow officers doing the best they could under tragic, rapidly evolving emotional circumstances. What I also saw was a young woman, Ms. Fitzsimmons, who was also a dedicated public servant, react to sudden, confusing, and heartbreaking news. Now let me turn to the evidence and the law. Our system of justice requires me to decide this case solely on the law and the evidence. So the only things I have considered in reaching my verdict are the 98 exhibits admitted during the trial and the testimony of the 11 witnesses that testified here in open court. While it may be cold and uncaring, our system of justice demands that emotion, sympathy, and concern for the consequences of my decision play no role in my decision. As for the law, in order to prove Ms. Fitzsimmons guilty of the crime of assault by means of a dangerous weapon, the Commonwealth must prove the following 3 things. We lawyers call these things elements beyond a reasonable doubt. First, that Ms. Simmons committed an assault on Officer Noonan. Second, that Ms. Simmons intended to commit the assault. And third, that the assault was committed by means of a dangerous weapon. The sole issue before me is whether the Commonwealth proved each of these 3 elements beyond a reasonable doubt. And more specifically, under the circumstances of this case, the narrow issue before me is whether the Commonwealth proved beyond a reasonable doubt that Ms. Fitzsimmons pointed a firearm at Officer Noonan for any perceptible amount of time. What is not before me are the legality of the issuance of the restraining order to Mr. Aylaian, the reasonableness of the procedure used by the police to serve the restraining order, the legality of Officer Noonan's use of force, and issues regarding the custody of Caden. It is not my place to decide these issues or even mention my thoughts on them. I am thankful for this because my role has been hard enough. What has made my job especially difficult in this case is that by and large, I found the testimony of Officer Noonan and Ms. Fitzsimmons to be credible on the material and relevant points. In my experience, this is unusual and somewhat perplexing. On the one hand, Ms. Fitzsimmons credibly testified that she never pointed a firearm at Officer Noonan. On the other hand, Officer Noonan testified that not only did Ms. Fitzsimmons point a gun at him, that she also pulled the trigger. Both agree that it happened in seconds near a narrow doorway, and the crime scene photos show that the door frame was made narrower by a clothes rack containing police uniforms that was to Officer Noonan's left. The door frame was also made, strike that, the door frame was made still narrower when Officer Noonan used it to take cover when he drew his firearm. During the closing argument, the Commonwealth argued that it is scientifically and physically impossible for Ms. Fitzsimmons' story to be true because there was a bullet in the chamber, and she said that Officer Noonan shot her without her ever racking the slide after pulling the trigger. I disagree that the evidence reflected that the only way to chamber a round would have been to pull the slide under those circumstances. However, even if I assume that Ms. Fitzsimmons lied about not racking the slide, it does not detract from the adamancy and credibility of her testimony that she never pointed the gun at Officer Noonan, about which he was equally as adamant that she did. Perhaps the Commonwealth could have easily met its burden if the officers had been wearing body cameras. But under these circumstances, I am left with a reasonable doubt, and I am duty-bound to find that the Commonwealth has not met its burden to prove that Ms. Fitzsimmons committed an assault by means of a dangerous weapon on Officer Noonan, and my verdict is, and must be, not guilty. With that, I will hand the signed verdict slip. Did I lose it? I will hand the signed verdict slip to Mr. Ruane and ask that he advise Ms. Fitzsimmons of her statutory rights.
Ms. Fitzsimmons, could you please stand? On docket 2025, 77 CR 311, count 001, the court having returned a verdict of not guilty, the court orders that you be discharged of this indictment, and this indictment only, and go thereof without delay. Kelsey Fitzsimmons, as required by statute, I must inform you that the records regarding the charges for which you have been found not guilty will be sealed by the Commissioner of Probation and by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want those records sealed. To request that those records not be sealed, you may use the request not to seal form posted on the trial court's webpage on mass.gov, or a copy of which I will hand to your counsel. I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. Do you understand?
Yes, I do.
Thank you.
Thank you. Court is in recess.
Good, all right. Please exit quietly, and thank you once again.
There you have it, a not guilty decision by the judge in the Kelsey Fitzsimmons trial. You see Kelsey right there.
All right.
Her lawyer right there.
Not guilty. Judge says Commonwealth had to prove that Kelsey committed assault, that she intended to commit said assault, and that she did it by means of a dangerous weapon. So they just did not prove it. I did find it interesting, like all the law enforcement are right there. Does that kind of remind you of another case? When law enforcement and the defendants were sitting in the front row. All right, we're gonna stick around for a press conference. So now you guys can answer the poll. What do you think about the verdict? Judge was fair and got it right, or it's a travesty? What do you guys think? He says his role has been hard enough. He found Kelsey to be credible, and it's unusual and perplexing. He said if she lied, it doesn't distract from her testimony. He says Noonan was just as adamant. Perhaps if law enforcement had been wearing body cam, we would know the answer. That's a huge throwdown right there. He says, I have my doubts, and thus my verdict is not guilty. So they had three things to prove. A, that she committed assault. B, that she intended to do that. And C, by means of a dangerous weapon. I don't think they met that. I don't think they met that at all. Especially the second one, that she intended to do that. I just do not think she didn't, or they didn't meet that. What do you guys think? Amby saying yes, definitely. Judge got it right. Iowa backyard cam. Snowcat-ish. There was so much reasonable doubt on both sides. No way to convict. Yep. And that was her dad. Okay, Pam, that was her actual dad, her biological dad. William, I think, right? Was that his name? William? I think was her bio dad, William. Oh no, Stephen. Stephen is her bio dad. She remarried. Lauren remarried to a William. So that's Stephen. Is that Stephen, her dad? Oh, and Aaron grabbed the restraining order, so we're going to take a look at that in a second. We'll take a look at that after after she walks out of the house. Stephen's a bio dad, yeah, gotcha. Excuse me. Thanks, Pammy, yeah. Oh, Joanne, are you taking off? Did I miss that? Have a great dinner? Okay. Have a good dinner, Joanne. All right. Yes, we got a screenshot. Let's see. All right. All right. Let me. Stephen is her bio. Okay. Thank you for that. Yep. That's what I have in my notes as well. All right. Let's see this RO. All right. That's the affidavit, but Aaron found the. Aaron found this. Where is it? All right. So check. There it is. To order that I be given possession, care, and control of the following animals. But there's no. He doesn't put in the name of Maverick. He doesn't put in the name of Maverick. So, beach life, salt air. Judge got it right. AWOL says, like I always say, it's free to spread love, but expensive to hate. Don't do the latter. So there it is. Okay, I see it now. So that is a lie. That was a straight up lie. The Commonwealth lied. Why would they do that? Why would you lie? You're calling Kelsey a liar, and yet here you are lying. What? What are they? What? All right, we got a press conference here. All right, hold on a sec. We'll go back to this.
Listen as we
Good
begin
afternoon,
with her
everybody.
attorney, Mr. Bradle.
It's just another day at the office today. Just want to say that we want to thank so many people. You know, we want to thank Kelsey and her family for having faith in us. We, meaning Martha and I, want to thank so many people that Kelsey and her family had faith in us. And you know, we had a very tough playing field for a long time. And we also want to thank Judge Karp, who did a great job and was a gentleman and treated us fairly and with justice, and that's all we ever asked for, and we finally got it, so we're relieved. And but other than thanking everybody, I just want to hand it over to Martha, and she's going to have some words for everybody first.
Yeah, so thanks, Tim. This is not only the right result, it's a righteous result today. It's been a long odyssey for those of you who followed this, and we started off in this case, you know, understanding, as we all do, and as the judge said, policing is a tough job. Being a mom is a tough job. And on June 30th, Kelsey had to do both. She's trying to be a mom. She's trying to get back to work. And then her world fell apart. And unfortunately on that day, as she said to the judge, and you heard in court, she had to deal with all that. And unfortunately, what happened in that bedroom started a chain of events with a narrative that they never diverged from. They never asked her about it. They rushed to judgment. And that case took on a life of its own, which unfortunately interfered with her life for an unnecessary and difficult time. I think Tim and I have known from the beginning that that wasn't fair, that the charges probably weren't fair, and that we were going to deal with the system, and we were going to take this to trial, and as Kelsey has said, without fail, she just wanted the truth to come out. She was able to do that when she testified in this case, and again, we're grateful for the judge's work. We're happy with this decision, and it's the right decision, as we said. She was always innocent until proven guilty. The Commonwealth did not meet their burden of proof, and she is innocent today.
Kelsey, what was it like to hear that word, not guilty? To hear the judge say not guilty this afternoon? You sat there, you know, you were on the stand yesterday telling your story. Share with us what that was like.
So, I got shot. I went to jail for 103 days. I haven't seen my son. I had to sell my home that I worked very hard for. So this is my first breath of fresh air, and I feel like I can breathe again. However, my fight is not over. I have a son that I need to reunite with, and that's where we are right now.
Can you talk to us about Eden, what's next for you, and how this verdict might help you reconnect with him?
I won't get into that, but I will say I am really excited to see my son again.
Do you have any plans to hire a personal injury attorney or have a personal injury attorney representing you?
I will also not get into that, but
yeah, today we're celebrating this verdict.
Yeah,
and that's
I'm
what we're
focusing on today.
One day at a time.
And I also would just like to thank everybody who stood outside each and every day, supported me, believed me before I got to tell my story, because it wasn't 9 months later until I got to tell the truth. And that was a long 9 months. And through those 9 months, you guys knew the truth. You guys believed in me, and thank you for that.
Kelsey, what's the message? Kelsey, what's the message to others that are in a position like yours after what happened today with the not guilty verdict? What would you tell other people?
Don't stop fighting for what's right, and when you know you didn't do something wrong, keep fighting for that.
Kelsey, do you want to be a police officer again?
I won't comment on that either. I don't know what my career goals are at the moment.
What have the last 9 months been like for you as a person, as a mother, as a defendant?
There's not a word. If you want an image of it, picture me on a mat in a jail cell crying for my son day after day after day after day. That's the only, there's not a word for that. But that is what happened to me.
Kelsey, do you feel like you're owed something now, considering that you've been found not guilty
going to leave that one to you.
Leave that one to the lawyers, Sarah.
Hey, Kelsey, the judge was not exactly speedy in getting to the ultimate decision. How painful was that to sit there and just wait for what was going to happen?
I mean, it's okay. He had to go through all the evidence, and there was a lot. So
We thought he was pretty quick, actually. And we, obviously, with a good judge, didn't have the issue with the jury. He told us when he was going to decide. We knew he was going to write his decision, which was helpful, and he told that in public. So we had this hybrid trial with the judge. He was both the judge and the jury, and he was forthcoming throughout the trial, transparent, and told us he was going to tell us why the decision, which, of course, we would not have gotten with the jury verdict. So it's helpful to have that as well.
Martha, you touched on how this is a just verdict, in your opinion. Were you surprised these charges were brought in the first place, and why do you think they were?
So I'm just going to repeat what I said earlier to that question. A set of things got set into motion on June 30th that then followed a narrative starting that night in that room that never really got challenged, that never really got investigated with any investigation of her, that never got tested in any way, but the presumption was that she was a defendant in this case. And so that's unfortunate because she couldn't talk for a while. She's being held for a while. She never got a chance really to tell her story. Ordinarily, the system shouldn't work that way, but both Attorney Bradel and I have been on both sides of the system. We know how it works, and sometimes when it doesn't work well and it works slowly, that's unfortunately what happened in this case. And we fought every way with Kelsey to make sure that justice was done. It took longer than it should have, we think. It was more painful than it should have been, but look, we got the right result today, and we are happy with that.
Kelsey, what's the next thing you want to do now that you're not guilty?
Guys, hold on. Let's give these guys over here a
Starting
chance.
today,
Go ahead.
all of your bail restrictions are lifted, and you said you can breathe again, but there's a lot of changes that are going to take place today. You have a lot more freedom than you had. How do you plan to start that journey of freedom?
I want to go for a walk with my dog. I can't wait to take him for a run. I haven't been able to do that. That's our thing, is going for a run. So.
And don't forget, she couldn't do that.
Right.
She had to sit in her house. That was her best case scenario, that she was a prisoner in her own home. And then her worst case scenario at the outset of this case, and like Martha said, this was such a bumpy road, a long bumpy road that never should have happened. And, you know, she had to spend time in prison. As a former police officer and corrections officer, she gets sent to jail, someone with no criminal record. Someone who shows up to court, has a wonderful history in this county, and sent to jail. To me, it's unprecedented. It terrorized her, and it's a horrendous, awful thing that happened. This case started out as a circus, and we are so grateful to end up in Lawrence in front of Judge Karp, who, like I said, is an absolute gentleman, a consummate jurist, and he treated everyone in that room with respect, with humanity, with kindness, and we were very appreciative for it.
Do you have a message to your former colleague?
No.
What did you make of the judge saying he credited both Kelsey's testimony and the testimony of Officer Noonan? He called it confusing.
Well, Charlie, you know, he's the fact finder. He's got to make the sausage in the back room. You know, he's got to think about everything, and you know, it's a tough job for any fact finder in any case, really. But I mean, you know, Kelsey has said to you guys every time we're out here, I can't wait to get to the truth. I can't wait for the truth to come out. And finally, she got her chance, and she told the truth, and she put herself out there. The one person in the whole room that didn't have to testify. She's the one that got up there, put herself out there, and told the truth. And the judge, I think, treated her wonderfully and was very humane and kind and listened attentively to not only her but to everybody in the case. And we're grateful for that.
And I'll just add two things to that. First of all, people can believe they're telling the truth when they're mistaken, so they can appear to be credible but be wrong. And when a defendant like this is credible, I think as Tim said in his opening and his closing, that creates reasonable doubt. And so that's the standard. The Commonwealth always has the burden beyond a reasonable doubt. We didn't know that one thing we weren't going to get was a hung jury here. So,
Josie, do you have a question? You okay?
Stop, sure you bring a little bit, it's okay. How are you feeling, Kelsey?
I feel good. I feel relieved. I was eager to do this, and I said from day one, the truth will come out, and it did.
Anybody
Maybe if
else?
this is doubling up, but you testified that 2 weeks is an eternity for any mom. The judge seemed, and even the prosecutor seemed to connect with that. 9 months.
There's not a word. There's not a word. It's the most devastating thing that you can do to a new mom. And hopefully changes will be made where a new mom or anyone will never have to go through something like this.
We've talked about that, and we're going to talk about that with legislators. What kind of a system is it that somebody can walk into court, fill out a piece of paper, and in 15 minutes, take someone's baby away, take a mom of a newborn's baby away? It's just an incredible thing, and it shouldn't happen. And we're going to work on some reforms of that statute.
Tim, how much impact do you think it had that the complainant had connections, friends within the law enforcement community? So maybe you can't be just anybody coming and filling out a form.
To be determined, Michael. To be determined. We have some other investigations to work on, and we're going to leave no stone unturned, and we're going to find out exactly how and why this happened, who's responsible, and we're not stopping here. The things that happened to Kelsey, we have, with respect to her home being broken into, we've reported that to the FBI. And I've had it with Essex County, and there are other avenues to pursue, and we're pursuing them. And we're in touch with the FBI on all sorts of federal crimes that were committed, and we're in the process of dealing with it there. That's one example of other avenues that we're taking here. We're not sitting here at Essex County's beck and call. We know where to go, and we know who to talk to, and we are doing that. Anybody else?
oh, great.
Thank you. Thank you, everybody.
Thanks, everybody.
Thank you. Thank you so much.
Listening to Kelsey Fitzsimmons and her legal team. As you can see, she is outside Essex Superior.
Well, those are definitely some fighting words, and I don't disagree with him. I think that how this happened definitely gave me pause. And it could be male, female as well. It could be a female getting an RO on a restraining order on a guy. I think it happened way too fast. There was no vetting. There was no, you had 12 days. I think 12 to 14 days to fight this. Like anybody can get a restraining order out on anybody, without any proof. That needs to change. I think that needs to change. There has to be some kind of vetting. There has to be some kind of looking into this. You know what I'm saying? Because I just feel like let's see, we can come over here. I just feel like it was just so easy for Justin to get this restraining order without any kind of proof. He basically just walked in and said, "This is my reality. This is what I'm saying." And I'm taking everything. I'm taking everything from this person. That's got to change, especially when there's a little kid involved, a baby involved. And then there's Maverick. There's her dog, Maverick. I didn't even realize until just now. There's Maverick. That has to change. That has to change. Bring CPS and get CPS involved. Get a social worker involved. Do some vetting. Instead of 12 days, you have 12 days. And I understand that courts are backed up and all that stuff, but 12 days, that pushed her over the edge. That pushed her over the edge for sure. So, brown-eyed girl, did he even have a birth certificate? I don't know. I don't know. Maverick is gorgeous, yeah. Let's see. Mal, you can't get regular restraining order without some sort of evidence, photos, texts, messages, etc. for the judge to review. This was an emergency ex parte order Justin filed. Yeah, no, I understand. I understand that. So why was he able to do that? Why was he able to do that? That's my question. Why was he able to just go in there without any proof and have this happen to her? That's what scares me. Wizard, that is the point of a temporary restraining order, so that it is vetted by a judge who signs off on it. It's temporary for 10 to 14 days. Yeah, I understand that, and I disagree with. I think something has to change. I think something has to change. Ruth Ann, exactly what happened was an injustice. Let's see. AWOL says, okay, I don't mind that rules need to change. How many fathers have had their rights taken away because court sided with the mom? I agree, but it should be even and fair. Yeah, 100%. Yes, agreed, 100%. A woman can't just walk in and say, boom, she has to have evidence. And we know there's been many times where a female has said, he's beating me, and the cops are like, well, we can't do anything about it. And then that person gets taken out or gets beat even further. So there's got to be something that protects the person who's going in and the person who is coming out, who the RO is coming out against. Because in this case, I think the system failed Kelsey. I think if this had been vetted, I think if child protections had been called in and she had been interviewed for a half hour or an hour, I don't think this would have happened. Wizard, but what would have been, but what would have been the case if what Justin said was true down to the bone? Well, what was the proof? I think that's the proof. To me, what would be the proof? Then he's got the proof. What was the proof? There was no proof. From what I saw, he didn't have any proof other than him saying. He didn't have a recording. He didn't have video. He had nothing other than she's doing this to me. And I understand that you don't always have that luxury. You don't always have video. You don't always have audio. But, okay, so if Justin was okay, that's still okay. Let's say Justin was absolutely true and Kelsey's the worst mother in the world and she's drunk and she's doing all these terrible things to him and baby C. I think CPS should still have been involved. I think CPS should have been involved and interviewed her with the police there. Police show up, they say, hey, we've got this restraining order, but we're going to have, CPS is going to talk to you and we're going to see if we can find, see what we can do. I still think CPS should have been involved. Let's see, walk on heels. I'm not saying what happened was right either, but not all DV victims have proof. No, I agree, and that's the sad thing. That's what's sad. We've seen too many cases where a woman is like, "Hey, he's doing this. He's beating on me," and the cops are like, "We can't do anything about it." Or once you have a black eye or you have proof, then come back to us, and then it's too late. We've seen that, unfortunately. Squinty Bubbles, yes, CPS were conspicuous by their absence. Kimmy, how are you? Selena K, I wanted to say happy birthday to you before I forget and we get too far down the road. Happy birthday! Sunday is your birthday. We may stream. We may have a stream for you guys. If we do, it's going to be a short one, but we may have a stream for you guys. Dina, totally agree. Thank you. Kathy, CPS should have been there for a handover of child. Absolutely. Horse welfare. Do we know what happened at that party? No, I don't. My chat is working, yes and no, Aaron. Aaron's asking, and it's just easier for me to say. It's working, yes and no. Yes and no, it's working. It's working, but it's not working as best as we would want it to work. All right, Jadzia Dax. No one testified that she assaulted Justin either. I find that interesting when they were at a joint bachelor or bachelorette party. I wish that had come in, but the judge says, nope, we're not going to allow anything that has nothing to do with that, even though it had everything to do with that. He was not going to allow that in. Maybe in the custody hearing that will be allowed in, but judge did not allow that in. Judge did not allow that in. I'm going to end this poll. All right, 91 votes, 100% of you. Nice, 100% of you are happy with the verdict. 91 votes, 100% happy with the verdict. All right. Kimmy, I listened to the microdots. Yeah, if you guys are not familiar with microdots, yeah, definitely go check that out. Selena, I've never had a birthday stream that would make my day. Hint, hint. All right, we'll see. We'll see what we can get for you. Yorkie's mom, what is on the docket for next week? That's a great question. I know what I want to stream, and we're trying to find a stream, and it's hard. But we're gonna have to see we're gonna have to see what's on the docket for next week. We have some work to do this weekend. I know what we want to stream, but there's only one source that has it, and that's another content creator. So we have to figure out where they got that from. So yeah, I can't say anything more than that. We'll have something for you guys. Don't worry. We definitely will have something for you guys. Horse welfare. Me too. I missed this channel so much during the restrictions. I know. Thank you guys. Really appreciate your support and your efforts. What did widespread say? Let me see. Let's see. I can't go back that far. All right. Ronnie V says, after listening to those audio recordings of Justin, he was probably being nasty to Kelsey and she slapped him. Let's see. Grampy, good. Mr. Noonan couldn't pull out his phone fast enough to vote. Right. Brat, yeah, the way they handled the order was weird. The accuser wandering her house unsupervised. Yeah. And again, the judge said he wasn't going to get into that. The judge said that's not before him. The only thing that's before him right now is that room. Did Kelsey assault, intend, and do it with a dangerous weapon? Those were the only three things that were in front of him. Just what happened in that moment in that room. Nothing else was before him. So kind of ties your hands, when you think about it. Ties your hands. Betsy, I think you guys need a good night's sleep and then decide because of YouTube being crazy. Yeah, we'll have something for you guys. Don't worry. We'll have something for you. I think Sunday we'll do something on Sunday. I have to do some yard work this weekend, so that's going to be tomorrow, and then Sunday we'll do we have a short stream for you guys, maybe about an hour and a half, 2 hours. We'll see. Red Snap, when you were shut down, it felt like the floor fell out from under. Yeah. Now you know. Think about how we felt. Yeah, think about how we felt. We thought that we were going to lose it like for good too. There was some rumor that we might never come back. Can you imagine? Ugh. Conrad, happy birthday to Selena. Yorkie's mom, Charles Jones is coming up on the 8th of April. Jury selection starts the 8th. So we have next week. We got to fill some time next week. So there's a trial happening right now that it's a couple days old and I want to cover it. But we have to find a source that we can stream it. So yeah, Charles Jones, Julio Fulio starts April 8th. We have to get with Florida PI Sam this weekend. That's another thing we have to do is get with her. She's been sending us all kinds of information that we cannot show you because it's insider information, but it's for our own benefit. So
it's allowable, but she doesn't want it to be allowable for us.
Yeah, it's to gain. It's for us to get educated on.
It's nothing.
But we can't stream it. We can't stream it.
She is a lawyer, so she's not sending us anything she shouldn't.
Yeah, oh yeah, absolutely. Squinty Bubbles, April 8th is your birthday. Awesome. Well, please come in and remind us, and we'll tell you happy birthday for sure. I think that's when jury selection starts. So it's probably going to be at least a day, maybe. I don't think it'll be 2 days because this happened in Tampa, and they're all from Jacksonville. So I don't think people know what's going on. So I would suspect they'll get a jury within 1 day. So we'll do a deep dive on that day, and then we'll pick up the trial when it starts. Yes, horse welfare, Julio Fulio. He was a rapper. He was part of the. There's two. Real briefly, there's two two factions, two groups. So I don't want to say that. There's two groups of people that don't like each other, and I'm not going to say the G word because I don't want to get in trouble. So there's two groups of people in Jacksonville that are rappers, and they don't like each other. They're from two different neighborhoods, and they basically it's called drill rap, and it basically they rap about taking each other out, and they mention names. They say this person, that person, this person. So we're going to get all into that and Florida PI Sam is representing one of the defendants. So we're going to get all involved in that. So Wizard, no, it didn't. It did not get severed. It did not get severed. I'm trying to find your chat. It did not get severed. So Missy, there you are. Got to run. All right. Maybe see you on Sunday. Cool. All right. We're gonna say goodbye too. We'll wrap it up, guys. Thank you so much for your support. Not only just being with us, but financially, and all the super chats and the memberships. You're helping grow our channel. I know. Speaking for Erin, she just stepped out. We really do appreciate it. This is a wonderful community that we've established, but you guys have helped it grow. We can only do so much. We can just provide the content, and you guys make it what it is. To be quite honest, you make it what it is. So we really appreciate the outpouring of love and support that you guys gave us for the what's about 20-30 hours we were offline. We had, I think, we posted on Twitter. We have 8,000 impressions on Twitter. We have people, yelling at YouTube, or not yelling, but texting them saying, "What's going on? Why are we taking offline when everybody else is online?" And then I posted in our community, and there's 300 comments there. So we know you guys are out there. We really do appreciate you, and we appreciate the cups of coffee. We appreciate the super stickers, the memberships. That's obviously helps us continue to be here and provide a space for you guys. So again, just thank you so much. Really do appreciate that. We have a lot of really fun things. I got a lemon pound cake in the can. I was editing it, and I was editing it this afternoon, and just for giggles, I checked in to see if I could stream, and boink, it popped up. So I'm like, sweet. So we decided to jump on live. But I'm going to go back to editing that a lemon pound cake. Richard, you said you have one you're going to drop on Sunday. So we're going to have dueling lemon pound cakes. So we have that. I'm going to get more music involved. I've been holding off on that because of one reason that still may come to fruition, but I may not hold off on that much longer because I want to get some music out there for you guys too. So Red Pen, thank you. Yes, 15 months. Thank you, Red Pen. Really appreciate that. So, all right, you guys, with all that being said, Super Ball, come here. Super Ball, come here. Come here. Come say goodbye. Come here. Come on. Super Ball. Yo, Super Ball. Dude, hey, come here. Yeah, come here. Come here. Yo, that's my good girl. All right. Super Ball is so thankful to you all. Super Ball is thankful to you all. And are you glad that we're back? Super Ball is glad that we're back too. So Super Ball is glad that we're back. Here. Oh, somebody just climbed up. Is that Sid or Riker? I can't quite tell. I think that's, hey, who are you? Yo. Okay, that's Riker. Are you Riker? I think that's Riker. And we got Super Ball over here. Yeah, it's a good girl. Yum. All right, you guys. I got my Wendy 8-ball shirt. Oh, we created a new shirt that says hashtag lemon pound cake. So if you guys want to go check that out, that would be cool too. All right. Thank you for joining us. Thank you to our mods. Thank you to Erin. Thank you to YouTube for lifting the restriction on us. We really do appreciate it. I have nothing but glowing things to say about YouTube because it's allowing us to have this space. So USMC, thank you so much for that. Did you receive one? You gifted one yourself. I love when that happens. You gifted a membership for yourself. That's so funny. USMC, you gifted, you thank you for the gifted memberships, and you gave yourself one. I love when that happens. That is fantastic. Squinty Bubbles, you got one too. Awesome. Jen Elrod, Jen, we know you. Let's see, Paula, Kathy, awesome. USMC, I love when that happens. All right, guys. Thanks again for joining us, and we will see you probably Sunday. I don't know if 100% sure. We'll probably do it on Sunday. If we do, maybe like 1 to 2, something like that. So if not, if you don't see us on Sunday, then we'll have something for you on Monday. All right, guys. Have a great weekend. Have a great rest of your evening. And with that, I will say good night. Bye.